Okay, so I think we'll get started. It looks like most of the people have joined, and people can continue to join in as the presentation goes on. I think I'd like to get started to respect everyone's time. So again, good afternoon, everyone, and thank you for taking the time to participate in today's webinar. The topic seems to have generated quite a bit of interest because we had a lot of response and people register for the seminar, for the webinar. Today's webinar will address the Department of Labor's recent ruling to expand FMLA protections to same-gendered spouses. What I think is interesting is that the ruling was just issued February 25th, and it's set to go into effect on March 27th, so very little time. It's important, too, because even if an employer may not have employees who are in this category now, that could change and change quickly, so employers should be prepared to review and update FMLA policies and procedures as necessary. By way of brief background, my name is Scott Bostley. I'm the Managing Partner of Benefit Strategy Partners, and I'll be the moderator for today's webinar. The presenter is Adam Hamel, an attorney at McLane Law Firm, which is a full-service firm with offices in Manchester, Portsmouth, and Concord, New Hampshire, as well as Woburn, Mass. Adam's practice concentrates in the areas of business, employment, and probate litigation. So before I turn this over to Adam, there will be a question and answer period at the conclusion of the webinar. However, if you have a question, please submit it using the question feature on your control panel anytime during Adam's presentation. So with that, I turn this over to Adam.
Thank you very much, Scott, and thank you all again for taking the time out of your day to participate in today's webinar. And so we're going to spend some time today talking about the Department of Labor's new regulations regarding the FMLA. And what I'm going to do is I'm going to start out with a very brief and basic overview of just kind of the essential provisions of the FMLA, just to put the new regulations in context. And then after I've done that, I'll sort of explain in some detail what the new regulations require and what they're all about. And then we'll have some time, as Scott said at the end, to take some questions. So first of all, the sort of the basics of the Family Medical and Leave Act is this is an act that entitles eligible employees of covered employers to take unpaid job-protected leave for specified family and medical reasons with a continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken the leave. And then, you kind of break that down into its component parts. The first element, basically, is that, it only applies for eligible employees. And so what is an eligible employee? An eligible employee is someone who works for a covered employer, and we'll talk about that in just a moment. And it's someone who has worked for the employer for at least 12 months, has at least 1,250 hours of service for the employer during the 12 months immediately preceding the leave, and also is someone who works at a location where the employer has at least 50 employees within 75 miles. So then getting back to now, well, what is a covered employer? A covered employer is one of three things. It's a private sector employer that has 50 or more employees in 20 or more work weeks in the current or preceding calendar year. So that will address the situation where an employer doesn't have 50 or more employees every week of the year, but through it has some ebbs and flows in their employee count throughout the year. So that's how that works. A covered employer also includes a public agency, including local, state, or federal government agencies, regardless of the number of employees, as well as any public or private elementary or secondary school, again, without regard to the number of employees. So then we're looking next at what it is exactly that the FMLA provides, and it's unpaid job-protected leave, and so that can comprise sort of eligible employees are allowed to take up to 12 work weeks of unpaid leave in a 12-month period. They can, under certain circumstances, take that leave in an intermittent or a reduced schedule basis. Doesn't necessarily have to be taken all in one big chunk. Employers may choose, or employers may require by policy that employees use accrued paid time off to cover some or all of the FMLA leave. So paid time off can be taken concurrently with FMLA leave. There are some other benefits as well that apply in the context of people in the armed forces. And so eligible employees can take up to 26 work weeks of unpaid leave during a 12-month period to care for a spouse, son, daughter, parent, or next of kin who is a covered service member with a serious injury or illness incurred or aggravated in the line of duty. And then also there's some eligibility under the FMLA to take some time in connection with a qualifying exigency related to the foreign deployment of an employee's spouse, son, or daughter or parent. So this kind of leads into the next sort of element, if you will, of what the FMLA is all about. So this leave is something that can be used for what are called specified family and medical reasons. And so those family and medical reasons include the two things that I just mentioned with regard to military purposes, but also it can be used for the birth, adoption, or foster care placement of a child of the employee, to care for a spouse, son, daughter, or parent who has a serious health condition, and also for a serious health condition that makes the employee themselves unable to perform the essential functions of his or her job. So now we kind of get to, that puts things into context, and we get to really kind of the meat of where we're at today and what we're talking about here today. Is that, two of these reasons that we've been talking about deal with, things that affect the employee's spouse. So the question then is, who qualifies as a spouse under the FMLA and for FMLA purposes? Well, it's not really necessarily a very easy question to answer. The statute itself, the actual statute in the U.S. Code, the FMLA, all it says is that a spouse is a husband or a wife, as the case may be. Well, that's not really a very helpful definition. It's kind of a bit circular, and it raises even more questions than it answers. So when and that's where the Department of Labor and regulations come into play, and that's often the case with federal statutes. So when the FMLA was first enacted in 1993, the Department of Labor issued an interim rule that defined who was a spouse. And that definition initially was a husband or wife as defined or recognized under state law for purposes of marriage, including common law marriage in states where it's recognized. Well, that interim law regulation in 1993 raised a lot of questions in and of itself. So, for example, well, which state law are we looking at here? And so in 1995, the Department of Labor issued a final rule that clarified that it's the law of the state where the employee resides controls in determining who qualifies as a spouse. So it's immaterial under the 1995 regulation where the party or the employee got married. What is important for purposes of the 1995 regulation is where they are residing at the time they're seeking to make use of FMLA benefits. So then, after 1995, they get the regulation in place, and then Congress throws a monkey wrench into it by enacting the Defense of Marriage Act. And the Defense of Marriage Act, Section 3 of that law, provides that in determining the meaning of any act of Congress or any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the word marriage means only a legal union between one man and one woman as husband and wife, and the word spouse refers only to a person of the opposite sex who is a husband or wife. So that changes things with regard to what the 1995 regulation set out. So it's now, for the purposes of federal statutes like FMLA, it's immaterial as to whether or not that marriage is recognized under state law. What matters is whether or not it meets the definition under DOMA. So as a result of DOMA, Labor limited the application of FMLA spousal leave only to opposite-sex marriages. Now, it's important to recognize, though, that while the Department of Labor, was bound by DOMA, that 1995 regulation stayed on the books. So even though it wasn't being enforced and it was superseded by DOMA, the 1995 regulation was still listed in the Code of Federal Regulations. So now we fast forward several years to 2013, when we have the case of the United States versus Windsor. And so this is a case that involved this woman who's pictured here, Edith Windsor. And Edith Windsor and Taya Spire were legally married in Ontario, Canada in 2007. They apparently had been in a very long-term committed relationship for many years before that, but they finally ultimately got legally married in Canada in 2007. Spire died in 2009, and as a result of Section 3 of DOMA, Edith Windsor was not able to take advantage of the federal estate tax exemption for surviving spouses. And so she challenged the constitutionality of DOMA because it prevented her from exercising the rights under the estate tax exemption. And eventually in June 2013, the United States Supreme Court held that Section 3 of DOMA violates the Due Process Clause of the Fifth Amendment and invalidated that law. So what happens next then is that after the Windsor decision, the Department of Labor immediately reverted back to its prior definition of spouse as a husband or a wife as defined or recognized under state law for purposes of marriage in the state where the employee resides. So again, this is that 1995 regulation that was always on the books. So when DOMA falls away, the pre-existing regulation just comes right back to life. But also in connection with the issuance of the Windsor decision, President Obama also gave a directive to all of the cabinet level secretaries, asking them to review all of the relevant statutes to make sure that the Windsor decision was being implemented fully. And so the Department of Labor sort of took another closer look at that and issued a new final rule in February, on February 25th, after a period of public comment. And it makes a rather significant change. So as we've discussed a little bit, the prior rule, which is the rule that's currently in effect as of today, is a rule that applies what could be called the place of residence test, and it looks at what the state where the employee resides to determine which state law is going to govern whether or not they are married for purposes of FMLA. So this new rule that is going to go into effect on March 27th, it shifts, and instead of a place of residence test, it applies a place of celebration test. So in the next screen, that'll be made a little bit more clear. But basically, instead of looking to the place of residence of the employee, what we're looking at is the place in which the marriage took place, regardless of where the employee is living at the time that they are seeking to use their benefits under FMLA. And so the Department of Labor has explained that the purpose of this change in the rule is to ensure that all legally married couples, whether opposite sex or same sex, will have a consistent federal family leave rights regardless of where they live. Another sort of piece of this in terms of the concept of consistency is that the fact that the Department of Defense has also adopted a place of celebration test for determining who qualifies as a spouse for military purposes, for military benefits, et cetera. And so, considering that the FMLA also provides for leave benefits in the military context, the Department of Labor thought that it was important for the DOL and the DOD to be on the same page with regard to who qualifies as a spouse. And so, and also in the comment period prior to the Department of Labor issuing this final rule, several employers or many employers have expressed that they believe that the place of celebration rule or test will be easier for employers to apply, because all you need to do under the place of celebration test is answer the question, well, is there a valid marriage license, or is this a marriage that was recognized under the state law of the place where the marriage was entered into, rather than having employers have to deal with kind of what can be thorny questions of where exactly legally does the employee reside, because the question of, for legal purposes, the residence can be a complicated question. And also, currently there's some question in several states. Think about what's gone on in the last month or so in Alabama. There's been a lot of confusion about the state of same-sex marriage in Alabama, and so that could cause some problems for employers. If you're an Alabama-based employer and you've got an employee who has a legal same-sex marriage that was entered into in, say, New Hampshire, and that employee is working in Alabama, well, does Alabama recognize same-sex marriage? We don't know. The place of celebration test removes all of that uncertainty for the employer. So this is the actual text of the new regulation that's going to go into effect later this month, and it's the new definition of spouse for family medical leave purposes. And what it says is that a spouse, as defined in the statute, FMLA, means a husband or a wife. For purposes of this definition, husband or wife refers to the other person with whom an individual entered into a marriage as defined or recognized under state law for purposes of marriage in the state in which the marriage was entered into, or in the case of a marriage entered into outside of any state, in other words, a foreign country, if the marriage is valid in the place where it was entered into and could have been entered into in at least one state. This definition includes an individual in a same-sex or common law marriage that either was entered into in a state that recognizes such marriages, or if entered into outside of any state, is valid in the place where it was entered into and could have been entered into in at least one state. So that's the actual text of the new regulation going into effect later this month. So, a lot of the focus on the new regulation has been with regard to same-sex marriages. But now it also raises the question, well, what about common law marriages? And there still are, a number of states in the country that recognize common law marriage. And so this new regulation also affects those marriages. And so the new regulation's place of celebration test permits leave for employees in common law marriages that were entered into in a state that recognizes such marriages. So under the prior regulations place of residence test, employees could only rely on the common law marriage status if the state in which the employee resided recognizes common law marriages. So, this potentially increases the number of employees who could qualify for FMLA leave based on a common law marriage status. This also raises, for me, another issue about, documentation. So, under the applicable law, FMLA, employers are able to request that an employee seeking to take advantage of FMLA benefits for for a spouse, you can require by policy that employees provide documentation. The question is, what kind of documentation can you ask for and what will satisfy? So basically, any kind of official document, whether it's a marriage license or some court document that demonstrates that the marriage has taken place. But also, the statute actually provides what is called in the statute a simple statement from the employee. And really, there's no guidance as to what exactly that statement has to include. But really, it is the employee's choice as to what kind of documentation to provide. So, an employee, especially perhaps in the context of a common law marriage, won't necessarily have any kind of official document relating to that. So they could satisfy that requirement with sort of a simple written statement. If you are in the position of wanting to have employees document the basis for using FMLA benefits for a spousal purpose, you'd want to make sure that policy is clearly stated and also uniformly applied. You'd want to be careful not to necessarily be seeking documentation, for instance, only from same-sex marriages and not from opposite-sex marriages. You want to make sure you're applying that policy in a uniform manner to avoid any kind of claims of discriminatory application. Another question that kind of gets raised here is, well, what about spouses who are working for the same employer? This is already addressed in the regulations. So existing regulations concerning employees working for the same employer, they remain unchanged, and now they're going to apply equally to employees in opposite sex, same sex, and common law marriages. And sort of essentially, in a nutshell, what this regulation provides is that employers may, by policy, limit the time that couples can take for FMLA leave to a combined maximum total of 12 weeks for any single FMLA purpose. So, for instance, you have a married couple that has a baby, and they're both working for the same employer. So the employer can choose to limit that time that couple takes to 12 weeks total, rather than stacking the time. Now, what about civil unions and domestic partnerships? Sort of as an initial interim step before before several states were adopting same-sex marriage. They were offering civil unions to same-sex couples. But even as that same-sex marriage has expanded to more and more states, there are still several states that do offer civil unions as an alternative to marriage, either to same-sex couples, or in some instances, in some states, civil unions is something that is available to both same-sex and opposite-sex couples. And then also there are states, primarily out in the western part of the country, that offer domestic partnerships, again, as an alternative to marriage. The Department of Labor has taken the position, that these arrangements, they are not recognized as marriages for FMLA purposes, and therefore the eligibility for leave rights on the basis of this status is not guaranteed. And I think that that the reason why the Department of Labor is the way that they word it is saying that it's not guaranteed, because again, if you're in a situation where you have a state where a civil union is available to a same-sex couple, but same-sex marriage is not available to them in that state, again, there's sort of a possibility that that status could be challenged. But I think that if we're in a state where there's sort of a menu of options that are available to couples, whether it be marriage is available to all couples and civil unions are available to all couples, if a couple chooses to enter into a civil union as opposed to a marriage, even if they have that option, then I think that the DOL probably would take the position that FMLA leave is not available to those people in a domestic partnership or a civil union. And then just also keep in mind that especially in the context of things like civil unions and domestic partnerships, that employers are always free to provide benefits that are greater than the minimum of what is required under FMLA. So, an employer could choose to treat civil unions, domestic partnerships, and marriages all equally, as long as the minimum benefits are provided for. So then we talk about, well, what about stepchildren? Does the new regulation affect stepchildren? So under the new rule, eligible employees in a same-sex or common law marriage can take leave to care for a stepchild without regard to whether or not the employee stands what's called in loco parentis, or just Latin for in the place of a parent, to the child. Now the Department of Labor points out that it has always recognized the eligibility of employees, whether married or not, to take leave to care for a partner's child if the employee met the in loco parentis requirement. And so basically what that means is that someone who either assumes or discharges the duties of a parent for a child with whom he has no legal or biological connection still is entitled to make use of FMLA time in connection with that child. And there is a lot of there's some more guidance in the regulations, and there's probably some case law about this too, in terms of exactly what you need to do to sort of meet that in loco parentis standard. But essentially, kind of what it's looking at is, are you providing day-to-day care for the child? Are you providing financial support to that child? And there'll be a pretty fact-intensive inquiry as to whether or not that really applies. But so this potentially. The regulation potentially expands the availability of FMLA leave to care for stepchildren. Now, how about step parents? So again, this is another possible expansion under the new regulation. So the new rule permits an eligible employee to take leave to care for a step parent who is the same-sex spouse of the employee's parent. Now, this is regardless of whether or not the step-parent ever stood in loco parentis to the employee. So, for instance, you have an adult employee whose mother or father, after the employee became an adult, enters into a same-sex marriage. Even so, that new same-sex spouse of the employee's parent never stood, in loco parentis to the employee, but just by virtue of the marital relationship with the employee's parent, they're now covered. But here's something that has not changed: is that FMLA leave is not now, or it never has been, available to care for parents-in-law of the employee. So what's on the horizon now? So that's kind of the scope and the possible impacts of this new regulation. but there's always change on the horizon, and in the pretty near future, things could change, perhaps in a pretty dramatic way. There currently are 4 cases pending at the United States Supreme Court addressing the issue of same-sex marriage. And these 4 cases are all scheduled to be argued together on April 28th. And every expectation is that a decision will issue at the end of this Supreme Court term. So either late June, early July, we'll have a decision on this. And the issue in these cases really is the ultimate issue on the question of same-sex marriage, is whether or not the 14th Amendment requires states to issue marriage licenses to same-sex couples and to recognize out-of-state or same-sex marriages. And so, depending upon the outcome of these cases, if the Supreme Court does, in fact, decide that the 14th Amendment does require all states to recognize same-sex marriages, then this new regulation that's gone into place, perhaps becomes moot, because then the definition of a spouse for all purposes would change to include same-sex marriages. There still would be the question of what would happen with regard to common law marriages, and I would have no reason to expect that the DOL would change its position with regard to what it currently has going into effect at the end of this month, that place of celebration rule for common law marriages. But again, this is something to keep in mind and to keep an eye out for as we go into the summer. The changes on the horizon. So then, the question then is, what should you be doing now? And I think that, what employers want to be doing now before this new regulation goes into effect at the end of the month is to, just review what your current FMLA policies are, and see if there's any changes that you need to make to clarify any language with regard to the meaning of spouse. Perhaps for employers who are, entirely based in Massachusetts and New Hampshire, states that that do recognize same-sex marriage, perhaps there might not be a lot that you need to do, or this might not have a huge impact on you. But if you are an employer that has facilities elsewhere in the country and you have employees hailing from all different parts of the country, this may be something to take a closer look at and to be aware of. And again, keep an eye on what's going on in the Supreme Court. So that's basically kind of the summary of what's going on, what's happening. And so before I turn it over to questions, I just wanted to put in a quick plug for the McLane Law Firm's New Hampshire Employment Law Update, which is coming up in a few weeks on April 2nd from 8 a.m. to 5 p.m. at the Sky Meadow Country Club in Nashua. And primarily the focus of this full-day seminar will be on New Hampshire and federal law, but also there will be a segment that I'll be presenting on several recent changes in Massachusetts employment law, such as the new mandatory paid sick time law, changes to the parental leave law and the minimum wage. So that's coming up. If you'd like more information about that, you can take a look at McLane's website. So at this point, I've done a lot of talking and given you a lot of information. So I'd like to turn it back over to Scott, who can share with us any questions that have been submitted.
All right, great. Thank you very much, Adam. Very useful information. So we will open it up for questions. Again, if you have a question you haven't asked yet, please do ask it via the question feature on your control panel and submit that. And we'll take questions for the next few minutes. I do have one right now, Adam. When it is a common law marriage, there often is no celebration. How does this apply? Because the place of celebration is not relevant.
Yeah, so I think that's an interesting choice of words. I mean, using the phrase place of celebration as the terminology for the test does really kind of envision a traditional marriage that's solemnized either in a religious ceremony or in getting married at the courthouse. I think that the rules and laws about common law marriage vary from state to state, and there are certain requirements that you have to meet in order to qualify for that. Things like you have to have an actual intent to be married. You have to hold yourself out as a married couple for a particular amount of time. But again, the requirements sort of vary from state to state. But there does come a point when all of those legal requirements to meet the status of common law marriage have been met, and you can say that as of X date, all of those requirements have been satisfied. And so I think that the regulation actually uses the word established, I think. And so there will become a point where common law marriage is legally established, and that will happen in a place where common law marriage is recognized. So what you'd be looking for is the employee to document in some way that the requirements of common law marriage have been established, and that status, you're entitled to have that status.
Gotcha. Great. We do have another question here. What is the difference between step-parents and parents-in-law?
So parents-in-law, that refers to, so for instance, you've got, so my wife's mother is my mother-in-law, but if my own mother were to get divorced and then get remarried, her new spouse would be my step-parent. But my wife's parents, those are my in-laws, and I'm not able to use FMLA time for them. But my own parents and any new spouse that they may have, that would be a step-parent.
Gotcha. Okay. There's nothing in queue right now, Adam, so I would like to ask, will you make the slides available after the presentation?
Yeah, I think that as we've done with these webinars in the past, I believe that the whole webinar is being recorded, and you could watch it. I think it's basically on YouTube, essentially, and so that all of the the audio and the slides would be available. But of course, obviously, anyone else who any of the registered participants who would like to have a copy of the slides, I'd be happy to provide them by email as well.
Sure. Okay. Great. So, Adam, I don't think there's any other questions at this point. I would like to close by saying certainly if there's any questions that come up after the presentation, either you think of them later or after you get the copies of these slides, feel free to reach out to Adam or myself, and we'll be happy to assist. Adam, I don't know if you have anything else to add.
Other than just, I want to just thank everyone for taking the time out of your day to learn about this. I mean, these issues are always, interesting and complicated, and they make our lives interesting. So it's good to be, to keep abreast of them. And again, just, thanks for taking the time to participate.
Great. Thank you so much. So that will conclude today's webinar. Thank you, everybody, for participating, and hope to have you participate in another one soon. Thank you.